Imagine this. You've just moved, right? And you sent in some really critical form, maybe for a government benefit or even like your kid's school application.
Yeah, something important.
Exactly. And you think it's all sorted, but weeks later you find out it was dismissed. Why? Because the official letter went to your old place.
Oh, no.
So you missed a deadline you didn't even know about. It feels incredibly unfair, doesn't it? You tried your best, but this technicality you couldn't control just tripped you up.
It happens more than you'd think.
Well, welcome to the deep dive. Today, we're going to cut through the legal jargon surrounding a really fascinating Supreme Court decision, Parrish v. United States. Our mission really is to unpack this ruling, not just as, a dry legal case, but as a kind of window into how our systems deal with real people facing these unexpected roadblocks.
Yeah, and what it means for anyone who's felt like they're battling bureaucracy, trying to do the right thing, but get caught in some procedural mess.
Yeah.
In this case, it really is about more than just deadlines. Fundamentally, it's about access to justice. It's about how the system treats people who are genuinely trying their best, often without a lawyer,
Right.
We'll see how a seemingly tiny procedural detail can have these huge consequences, and crucially, how the Supreme Court stepped in to, well, clarify things and maybe inject some common sense.
Okay, so let's start with the person at the center of it all, Dante Parrish. This whole legal journey begins with his story.
Right.
Back in 2009, he was in federal prison, and he got suspected of being involved in another inmate's death.
Okay.
This led to him being put in restrictive, segregated confinement for, get this, 23 months. Nearly 2 years.
Wow, that's a long time.
But here's the kicker. Long after that confinement ended, a hearing officer actually cleared him of any wrongdoing.
Got him. After the fact.
After almost 2 years in isolation. So you can imagine, this experience had definitely set the stage for him wanting to challenge what happened.
Absolutely.
Yeah.
So after he was cleared, he wasn't just going to, let it slide. He filed a lawsuit in federal district court,
Makes sense.
seeking damages for that wrongful confinement, alleging his due process rights were violated. But the district court dismissed his case. That was on March 23, 2020.
And why did they dismiss it?
Well, they said some claims were untimely, basically filed too late, and others were unexhausted.
Unexhausted, meaning?
Meaning he hadn't gone through all the required administrative steps before taking it to court. It's another procedural hurdle.
Okay, and this is where things get really complicated, procedurally speaking. The very next day, March 24th, 2020, the day after the dismissal,
Yeah.
Dante Parrish was transferred, moved from federal custody to a state penitentiary.
Ah. So he wasn't even at the federal prison anymore.
Exactly. So when the court's official dismissal order finally showed up at the federal prison, maybe 2 weeks later, he wasn't there. Through no fault of his own, he just couldn't receive it.
Right. And that physical move, that logistical issue, caused a significant delay. This delay becomes the absolute crux of the case.
How long was the delay?
He didn't actually get that dismissal order until June 25th, 2020. So a full 3 months after the court issued it.
3 months, okay.
But, and this is really important, as soon as he did get it, he acted fast.
Right.
He filed a notice of appeal on July 8th, 2020. And in that notice, he was very clear. He explained why it was late, citing the transfer and the delayed receipt.
Okay, now let's talk about deadlines. Because normally, in the legal world, you have, 30 days to appeal a civil judgment?
Typically, yes. But there's an exception.
When the government's involved.
Exactly. When the United States is a party, like it was here, you get 60 days.
60 days. So his appeal was filed in July for a judgment made back in March. That's clearly outside the 60 days.
Way outside. And these appeal deadlines, they aren't just guidelines. They're what lawyers call jurisdictional.
Jurisdictional. That sounds serious.
It is. It means if you miss the deadline, the court literally lacks the power, the jurisdiction, to even hear your case. Doesn't matter how strong your arguments are.
So for someone like Parrish, in custody, trying to navigate this, missing that deadline could mean his whole case just disappears.
Pretty much. It's a gatekeeper rule, and it's incredibly strict. A valid claim could be thrown out just because of a missed step.
Okay, but it seems the first court he appealed to, the Fourth Circuit, showed some initial understanding.
They did, initially. They saw his late notice, and instead of just tossing it, they did something interesting. They construed it. Basically, they interpreted it as a motion.
A motion to what?
As a motion to reopen the time he had to appeal. And this brings a specific federal law into play. 28 U.S.C. Section 2107C.
Section 2107C, what does that do?
Well, it's Congress basically acknowledging that stuff happens. It creates a bit of flexibility. It allows courts to reopen the time for appeal for a period of 14 days if a party didn't get notice of the decision within 21 days of it being entered.
Which Parrish clearly didn't.
Right. And there are a couple of other conditions. The motion to reopen has to be filed pretty quickly within 180 days of the judgment, or 14 days of actually receiving the notice, whichever comes first.
Okay.
And crucially, reopening the time can't prejudice anyone else, meaning it can't unfairly harm the other side.
And Parrish met all these.
Yes, he clearly met the criteria. He wasn't at fault for the delay. So this law, it's like a safety valve for situations just like this.
So the district court agreed and granted the reopening, gave him that extra 14 days.
It did. The district court granted the motion, giving Parrish a fresh 14-day window. It looked like he was back in the game.
But there's always a but, isn't there?
Uh-huh. Here's the twist. This is the specific issue that went all the way to the Supreme Court.
What happened?
Dante Parrish didn't file a second notice of appeal within that new 14-day window.
He didn't file again. Why not?
Well, you can imagine he probably thought, quite reasonably, I already filed my notice explaining the delay, and they just granted my request based on that filing. Why would I file the exact same thing again?
That seems logical.
It does. But the Fourth Circuit Court of Appeals saw it differently, and they dismissed his appeal again.
Again, on what grounds this time?
Their logic was, reopening the appeal period creates a brand new, separate 14-day window. That first notice he filed, the one that was technically late but explained the situation, they said that notice couldn't count for the new window. He needed to file a second one, specifically for that reopened period.
Wow, that seems very technical.
Extremely technical. And this created a split among the different federal appeals courts across the country.
Yeah.
Some agreed with the Fourth Circuit, others didn't. That circuit split is usually why the Supreme Court steps in.
To resolve the disagreement.
Exactly. And interestingly, both Parrish and the U.S. government actually agreed a second notice wasn't needed here.
Wait, the government agreed with him?
On this procedural point, yes. But the court appointed what's called an amicus curiae, a friend of the court, to argue the other side, just to make sure the issue was fully debated.
Okay, so that sets the stage. The Supreme Court takes the case. What was the fundamental question they were trying to answer?
It boiled down to this. When a court reopens an appeal window under Section 2107C, does someone who already filed a notice, even if it was technically early for the reopened period, need to file a brand new, identical one?
Or is that first notice good enough once the reopening is granted?
Precisely. Is the system really set up to demand that kind of, well, double filing when everyone knows what the person intends?
And what did the court say?
Justice Sotomayor wrote the majority opinion. And they drew a really important distinction. They differentiated between a notice filed too late, like after all possible deadlines have passed, which usually kills an appeal,
Right.
and a notice filed too early or prematurely. That distinction was key.
Too early versus too late. Okay, so how did that apply here?
This is where they brought in, or really reaffirmed, a principle called relation forward.
Relation forward. Okay, break that down for us, like in everyday terms.
Think of it like this. Imagine you're super eager for concert tickets to go on sale next Monday. You send your order form in on Friday because you're just ready.
Okay, a bit early.
Right. Your form is premature. But relation forward means that once Monday arrives and sales officially open, your Friday form is treated as if it arrived right on time. It relates forward to the moment it becomes effective.
Ah, okay. So your early action counts once the window opens.
Exactly. So an appeal notice filed before the formal order, making the appeal possible. In this case, the reopening order can relate forward and become effective once that order is actually issued. Your early notice holds your spot.
Got it. That makes intuitive sense.
And the court stressed, this isn't some new idea they just cooked up.
Yeah.
No, this principle has deep roots. It's been part of American law for well over a century, they said. They cited cases going way back.
Wow.
The core idea, then and now, is to avoid throwing out appeals based on mere technicalities, when there's absolutely no doubt about who's appealing, from what decision, and to which court.
It's about substance over form.
Exactly.
Yeah.
Making sure cases are decided on the merits, not on minor paperwork glitches that don't actually mislead or harm anyone. It's also about efficiency, avoiding pointless refilings.
You know, that really does connect to those frustrating moments many of us have faced as adults, like filling out mortgage applications, or government forms for benefits, or school enrollment.
Yeah.
It's maddening when your clear intention gets rejected because you ticked the wrong box or missed a signature on page 12, even though all the necessary info is right there.
It is. And this legal principle, at its heart, is trying to prevent that kind of bureaucratic gotcha in the court system, especially when fundamental rights are on the line.
So the court is saying this principle already exists in law.
Yes, they pointed out that the actual court rules, the federal rules of appellate procedure, already use this relation forward idea in other contexts.
Like where?
Rules 4A2 and 4A4, for instance. And they made a really interesting historical point.
What was that?
Back in 1993, one of these rules was specifically changed to remove restrictions on relation forward. Why? Because the old way created a trap for an unsuspecting litigant.
A trap?
Especially for people representing themselves. Pro se litigants, who often didn't realize they needed to file a second, identical notice. So there's a clear history here of moving towards more practical, less trap-like rules.
Okay, so what about the Fourth Circuit's main argument? That one document couldn't be both the motion to reopen and the notice of appeal?
The Supreme Court pushed back on that pretty firmly.
How so?
They said, look, there's plenty of legal precedent showing a single document can serve multiple purposes. What really matters is whether the filing clearly signals the person's intent to appeal. Does it provide proper notice?
And in Parrish's case?
In Parrish's case, his initial filing made his intent perfectly clear. There was no ambiguity.
Right.
So requiring him to file a second identical piece of paper, the court called that empty paper shuffling.
Empty paper shuffling. I like that phrase.
Yeah. A waste of time and resources, achieving nothing substantive, especially for someone just trying to get their case heard.
So, bottom line, what did the Supreme Court decide for Dante Parrish and for this rule?
They concluded that Section 2107C, the reopening statute, absolutely did not require Parrish to file a second notice.
Okay.
His original notice, even though technically early for the reopen period, effectively related forward to the date the reopening was granted.
So it became timely at that point.
Exactly. And that action legally gave the Fourth Circuit the jurisdiction they needed. His appeal could finally proceed based on its substance.
A big win for him, procedurally at least.
A huge hurdle cleared.
Now, even when the justices agree on the results, sometimes they have different reasons, right? Were there other opinions?
There were. Even though the outcome was pretty decisive, there were different perspectives on the why.
Okay, like what?
Well, Justice Jackson wrote a concurring opinion, and Justice Thomas joined her. She agreed with the outcome, no second notice needed.
But she had a different rationale.
Kind of, yeah. She suggested a simpler, maybe more administrative way to think about it. Her view is basically, look, if someone files a late document with a motion asking the court to accept it late.
Like Parrish did.
Right. And if the court grants that motion, then the document should just be officially recorded or docketed as if it were timely filed. End of story.
So less about complex legal principles like relation forward.
And more about just straightforward administrative common sense. If you say yes to accepting it late, then just accept it as timely. Simple.
Interesting. Okay, was there anyone who disagreed with the outcome entirely? A dissent?
Yes, Justice Gorsuch filed a dissenting opinion.
And what was his concern? Did he think Parrish should have filed a second notice?
Actually, no, his dissent wasn't really about the merits of the rule itself. His main issue was whether the Supreme Court should have even taken the case at all.
Oh, why not?
He pointed out that there's this specific body, the Advisory Committee on Appellate Rules. Their whole job is to study these kinds of procedural rules and recommend changes. And Justice Gorsuch noted that this very committee was already studying this exact issue, the premature notice problem after reopening.
Ah, so he felt the court was jumping the gun.
Essentially, yes. He argued it was more efficient and appropriate for that specialized committee to figure out the best fix, rather than the court stepping in, potentially disrupting the committee's work, and maybe not getting all the practical nuances right. It was more about the proper institutional roles.
Okay, that makes sense as a different kind of concern. So, stepping back from the legal intricacies, why does a case like this matter to, us, people maybe not dealing with federal court appeals?
Well, I think it's a really powerful reminder, actually. It shows that while rules and procedures are obviously necessary, especially in complex systems.
Right, you need rules.
You do. But the law, at its best, also strives for fairness and practicality. And that principle resonates far beyond the courtroom. Think about navigating any big system as an adult, dealing with insurance companies, maybe workplace bureaucracy, even trying to get your kid into the right school program. These systems can feel overwhelming.
Definitely.
And this case highlights a core idea. Your clear intent and genuine effort shouldn't be totally derailed by a rigid adherence to a minor procedural detail, especially if that detail acts like a trap for the unsuspecting, as the court said.
That phrase, again, it's about making systems accessible, right? Forgiving honest mistakes that don't actually hurt anyone.
Exactly. It's about designing systems, or at least interpreting the rules for those systems, with a dose of common sense and a focus on the actual goal, not just ticking boxes.
Yeah, it really feels like a win for the spirit of the law over the letter in this instance.
Yes.
Avoiding those traps, avoiding that empty paper shuffling.
Precisely.
So to wrap up, the Supreme Court in Parrish v. United States basically said, if someone makes their intent to kill clear and the system itself causes a delay or confusion around deadlines, courts should prioritize substance. That initial clear statement of intent can count, even if it's technically early for a reopened window. No need for pointless extra paperwork.
That's the core takeaway. Practicality and fairness trumping rigid formality when intent is clear and no one is harmed.
Which leaves us with a final thought to mull over. Where else? Where else in our own lives, maybe our workplaces, our communities, do we accidentally set up these traps for the unsuspecting?
Yeah.
Where do we prioritize rigid procedures over someone's clear intent or genuine effort, maybe without even realizing it? What systems out there could benefit from a little bit of that relation-forward common sense?
That's a great question to think about. How can we make the systems we interact with, or maybe even design, a bit more forgiving and focused on the real goal?
Something to keep in mind this week.